Well, welcome to the aftermath. And today we have a special guest here, Joe Cordell from Missouri. This is Mick, the Doctor of Digital, and a phenomenal co-host, Kendra Reiber, legislative tiger. How you doing today, Kendra?
I'm wonderful. Thanks, Mick. How are you?
I'm doing fantastic. It's life in San Diego, and it's always beautiful. So, with that as an introduction, too, we want to welcome Joe Cordell, who is our special guest today. We'd really been looking forward to having him on because we talked to a lot of number of people. But one of the things that's very interesting about Mr. Cordell's background is that he's an attorney, and people have asked and very curious about what the attorney side on the aftermath will be. So he is from Missouri. He has some websites, Dad's Divorce, Men's Rights, and he also has some really good videos on YouTube, which I'd hope to get into. Talks about children first, how to be a better co-parent. So, Joe, thank you for coming on the show. We appreciate you taking some time out to chat with us today. How are you today? And tell us a little bit about your background.
Well, I'm good. And thank you, Mick, for having me on the show. And Kendra, it's good to visit with you. Um, I'm a partner with the firm Cordell and Cordell. And my wife and I, in fact, originally founded the firm, which was 32 years ago. Time flies. But anyway, we represent men in domestic relations cases. Um, Probably 98%. My lawyers more recently tell me that it may be down to 96 to 95% of our clients are men. So we do represent some women, and they're typically referred to us by men, by their friends often. And of course, we're zealous in our representation of all our clients. But our firm has had a mission, which it's been very explicit about, and that's that we focus on serving men, especially in domestic relations matters regarding custody, but domestic relations generally.
Okay, interesting.
I'll tell you this too, we're probably I'm pretty confident we're the largest domestic relations firm in America. We're in some 42, 44 states. And we've been doing this for a long time. And over the course of that time, we found that there are a lot of similarities in the various jurisdictions. While some of the details matter in the broader sketches, there's a lot of similarity across the 50 states. And we have presently an office in the UK and have for the last, 3 years.
So, can you tell us a little bit about when legislation was written years ago, right? It was very much focused on the female or the mother, and mostly awarding rights to her, and the best interest of the children. Can you tell us a little bit about how that's evolved since you were at the beginning of that, probably, and what it looks like today?
Yeah, and let me take one step back to a period before, believe it or not, before I was practicing, being the 19th century. Some will find that news. So, but at that time, believe it or not, it was the opposite of what we think of as traditional buys. People who grew up in the second half of the 20th century assumed that, well, it must have always been that the stereotype of women, should be doing the nurturing and men should be out providing a paycheck. Well, that stereotype is largely a phenomenon, certainly of the 20th century, but I would even argue largely the second half of the 20th century. Prior to that, um, as with property, men were regarded in this very, very patriarchal societies, going back hundreds of years, were regarded as the presumptive person who was to control children as well as property. So, believe it or not, there was a time which none of us alive today experienced when there was a bias against women because it was just that overarching patriarchal view in the courts that encompassed everything, and kids got swept into that. So it wasn't an assumption necessarily that the dads were ever better parents. It's that they were the patriarch, so to speak, as with real estate. But uh, but then in the 20th century, everyone developed the presumption, and worst of all, the courts, that unless you can show me a very good reason, mom should be with the children. And there was even this doctrine that developed that was the governing criterion in a majority of states for many years. It's called the tender years presumption. And the tender years presumption said that a child under, and this age varied depending on the state. Sometimes it was 10, sometimes it was 7, but let's say 7 and under, that any child under 7 years old is almost as a conclusive presumption going to go to the mother, because the tender years doctrine said that, of course, men should not be entrusted with something as fragile as a child under age 7. So it was very bad at one time. And when I started practicing in the late 80s, there was still some of that, of course. And it I can happily report that it's better today than it was then. But I would hurry to add that it's still not a level playing field as to those presumptions.
Mhm.
There's a little bit of a context there, and I think that's what you're alluding to. So in the 19th century, it was not necessarily the interest of the child that was at stake, but the man could earn money. And so the thinking was, well, at least he was working and he had access to money, whereas a woman wasn't necessarily working outside the home in the 19th century. But then more recently, in the last 30, 40 years or so, with women's rights movements and women's liberation and women going back to work, they go into the work world. So I wanted to follow up with that, as that's the background historically, but the context then would be, are there differences between, and of course your law firm is in so many states, is there a difference between those that are more rural in background, which might be closer to the 19th century view, as opposed to the other states like New York, California, and those states that might be more like the so-called modern view? So in other words, what are the differences that you find across the country in different states based on this historical background of custody and parental alienation and divorce?
Well, I would pretty much say that the patriarchal presumption is largely dad rurally, and dad, of course, in urban areas. And what I guess assured its demise was the capacity of the courts to move money around. For example, I would have clients come in, not so much anymore, but at one time I would have clients come in who, and this would be a male client, and he would say, well, I have the ability to earn money, so shouldn't I be the one that would get primary custody? And you point out very correctly, Mick, that was a factor in that 19th century and before policy. But then I said, well, actually, no, because the courts is happy to move money around, and it has the authority and the means to do that. So it's a simple administrative matter in the 20th century, especially the latter 20th century, and it wasn't such a simple administrative matter before. So the courts could easily do a division of labor, which is in fact what resulted, was the presumption that the dad, he's capable of going out and earning money, and we have the administrative and legal machinery to move that money from him on an assured periodic basis into the hands of the nurturer as she needs it. Not to mention that would include maintenance probably too, which is supporting her in addition to the children. So clients naively, and I get the idea, they would think, well, gee, if I'm earning money, then why wouldn't that give me an edge? But oddly enough, it didn't give them an edge at all. As a matter of fact, it was a detriment, because the court would conclude that their requirements, to earn this money would be inhibited, or that they would be impaired as a wage earner if they had to have these additional responsibilities. So oddly enough, a doctor or a lawyer, people whose careers were demanding, were really almost at a disadvantage in a custody battle versus a mom who had a low-level job or a 40-hour week job, or better still, no job.
Mm-hmm.
Mm.
So, can you tell us a little bit, I guess, or go into a little bit more detail on representing men's rights? Does that mean you're going for full custody with a lot of your clients, or is this something where you're going 50-50, or you're looking in the best interest of the children? What does that look like?
Well, divorce is a messy thing, and it's something that there's a reason that all the major religions of the world deplore divorce, and it's it it creates very complicated sets of motives and whatnot, and children are caught in that, and they're caught in that even with loving parents. And so we represent guys who very often there's a custody issue. Um, and I'll stereotype a little bit, but it's a phenomenon that occurs, and that we recognize the pattern that with men in their late 40s, early 50s, um, they're vulnerable to having an affair, often in the workplace. These stereotypes, incidentally, may be fading as we get into the 20th century, but they were pretty reliable generalizations for 4 decades. But anyway, these guys would be vulnerable to relationships, perhaps opportunities they had never had before. Even they're reasonably successful, and so we've seen the movies and other things about these guys with women who are 5, maybe 10 years old, younger, generally not more than that. But the stereotype that gets little attention is really probably the foundation of our firm's success. Our firm's success is focused on representing guys who are fighting custody battles. Well, if you walk that back or go upstream, would be a better way to think about it. What are the likely underlying factors in that situation? Well, he's probably not a guy who's in his mid 40s and the kids are teenagers and dad has an affair and he's going to go off and marry his younger girlfriend, and these teenagers are going to go happily along. But those aren't custody battles in those cases generally, for the reasons that you all would quickly suspect. These kids would not be cooperative. But there are custody battles when there are divorces where children are younger, and more often than not, that means in the 30s. And here's the stereotype. If you tell me that a couple's getting divorced in their mid 40s, my wager would be that the guy's met somebody and he's initiated the divorce. If you tell me a couple is getting divorced and they're in their mid 30s, my wager is that the wife has met somebody else and she's moving on. Well, we might say that there's kind of parity there, but actually there isn't. In one case, there's going to be a very ugly custody battle. And in the other case, there's more money and there'll be an argument about that money, but at least children are not likely to be the victims other than the fact that goes with divorce anyway. But at least, let me put it this way, the kids are not subjected to a custody battle, when they're in their teenage years, for the most part. Sometimes they are. But anyway, so these guys, in answer to your question, these guys come in and it's hard to rise above that maelstrom of emotions. There's nothing like betrayal that goes with divorce and love, and Shakespeare made history on that subject, and so there are all those conflicting emotions are on the table or related to the divorce process. And children, unfortunately, and again going back to my first statement, even with loving parents, get caught in this. I mean, their parents are human beings, and yet they have a responsibility to rise above those emotions and think just about the children's best interests. Both would say they are. Both would proclaim that's exactly what they're doing. But it's just complicated. So divorce is very ugly, and there's lots of emotions going on, and kids, somehow are swept into that. Naturally, I would say in the scenario that I just described to you, that where the mom has met somebody else and she's wanting to move on, and she's walked in and she said to the guy, look, let's, usually it's vague phrases like, I love you, but I'm not in love with you. Those are big red flags to a divorce lawyer. When when the guy has been in jail for 3 weeks for a drunken brawl, you don't have to wonder why that, he might be receiving divorce papers. But if it's vague, then generally, almost without exception, there's somebody else. And so she's saying to him, look, let's do this in a business-like fashion. I mean, there's no need to be wasting money on divorce, on lawyers. And here's what let's do. I want to take the children with me, of course. I'm their mother. And I will need child support. And sometimes she might even throw in, I will need some maintenance. And whether she says it or not, she's hoping for the better half of the property. So is it surprising that such guys in such circumstances might be disinclined to be cooperative with that life plan that his wife has developed, which doesn't include him, and which would require him to give up a substantial part, if not most, of his time with his children. So
So,
that sets the stage.
okay, that makes a lot of sense. I will say it happens to women. I can say that I am, if for better sake of the word or term, I am the man in the relationship then. Everything you're describing is what I have gone through on the male side of things. And so I do think there is a problem that needs a solution, whether you are male or female experiencing those things. There definitely needs some solution.
And I think you raise a good point. And I sense this. I'm glad that I have lawyers who are younger than I am who will follow in my and have followed in my footsteps. Some would say that they've run past me. But anyway, I have younger lawyers who are more in tune with what these cultural social transitions have been over the last, say, 10 to 15 years. I practice much less today than I did, 10 years ago. But we have 300 and something lawyers. So I think that what's happening is the gender-based stereotype that I just described, where the divorce in the 30s was primarily the woman and the guy primarily, was older when that occurred. I do think that now it may be, it could happen either way in the 30s, but either way, you do have a custody battle. And as you described, if you were reverse the roles, what I described apparently your situation.
Yes. Yes. But Mick, which is why we connected, it is the typical male you described.
Yeah, this is the odd thing or the irony here. So as Kendra turned out to be the man in the relationship, it was almost the opposite for me. I was the woman. So when our child was 2 months old, my wife worked double shifts. And so literally she was not in the home at all. Then with sleeping and what have you, she was very preoccupied because she was working a lot. I took care of the baby when she was 2 months old and 3 months old and 4 months old. So I was the primary caregiver. So into the custody battle, that's what I argued for. Well, why are I'm not the primary caregiver? Because if I could take care of a 2-month-old child, I certainly can take care of when wife took off. She was 5 years by that point. But what you had alluded to earlier, the 10 years doctrine worked against me because the court was reluctant and didn't award me custody. I said, well, it made no sense in my situation because I was so-called, in quotes, I was the mother. I was mothering her when she was very small and could take care of her. But I wanted to follow up on this a little bit. And just if you could explain a little bit when Kendra asked the question about custody in general and explain the difference between physical and legal custody, because it's a basic question, but a lot of people don't understand the differences between the two. I think that might be a helpful point.
Yeah, it would. And let me clarify something too. The Tender's Years doctrine, which is still around in a de facto way, but in a legal way, it was declared unconstitutional. But that's of little gratification to people such as you, Mick, who find that it still lurks around. So legal versus physical. Physical is, as the name implies, it means actual physical time with the children. Legal means the ability to make major decisions in the children's lives. These decisions affect the health, education, welfare of the children. So it includes decisions about private schooling. It includes decisions about religion, healthcare. And now, at one time, healthcare wasn't such a discretionary thing. With every advance in technology, many of them, I would argue, not so healthy, but there end up being more choices that people can make, some very discretionary and some very long lasting, such as gender issues. So you can imagine where somebody has a parent has legal custody exclusively, sole legal. And even if there's joint physical, that parent with sole legal custody has the ability to authorize medical procedures that the other parent may vehemently oppose. But not just medical. Again, I mentioned religion. Religion, for many people, is the most important issue. But education, we've seen disputes where one parent is an advocate of homeschooling. I can tell you, my wife and I, we homeschooled our two daughters, and we're big believers in homeschooling. and we think it's a marvelous thing. I'll boast, both my daughters went to University of Chicago undergrad, and one is in medical school and the other's in law school now. So we're big proponents of homeschooling, but I've had cases where that was the issue, the joint legal issue. So if somebody thinks, well, the battleground should really involve physical time, well, I don't want to diminish physical time. Physical time is huge, but don't allow them to give you additional time and then say, and by the way, my client will get to make some decisions about just things that are unrelated to physical time. And sometimes dads especially are vulnerable if their lawyers aren't paying attention to making trades like that to settle custody disputes. But the legal custody is a big deal. And where one parent, for example, with the homeschooling, where one parent is an advocate and really wants that, and maybe it's been done even historically, and that was the case that I'm thinking of, where that's what they had done. And then the mom comes into court and takes the majority view, the cultural view, that you don't want to entrust kids to their parents like that. You need them to be in a classroom where they're taught the proper, values of the culture, not the values of the parents, which could be, Waco sort of things. So whatever that was, Branch Davidian, so all sorts of perversions of what homeschooling is. Well, that's an example where whoever has legal custody is going to make that call. And if there's joint legal custody, the judge is going to make the call if the parties come to a deadlock.
Yeah, so let's talk about the joint legal custody here for just a minute, since you mentioned that. Some of the states are passing laws like Kentucky, Arkansas, that are going to 50-50 custody, equal decision making in the children's lives after separation. Or divorce or dissolution, but usually separation, right away, unless there is proven evidence that the parent is unfit to make those decisions. What is your take on that, or your stance? Is that in the best interest of the children?
Not necessarily. Incidentally, it's a presumption, and as you suggested, it can be rebutted by proving certain things, but it's a pretty strong presumption. And it does tend to view the subject from the standpoint of property solutions. If this were 100 acres of land, then you would say, well, the presumption is, maybe the irrebuttable presumption in that case would be 50-50. So each person gets 50 acres and we should all be, as happy as we would otherwise have been. But the fact is, with children, the facts are so different that I think that a policy like that is really more property focused in its analysis than child focused. Now, I will tell you that I was an advocate in the days when something that you just read, there was a time when in the men's rights movement, when what you just read would have been the biggest and grandest and greatest victory they could ever hope for. And there are still some people in the fathers' rights movement who take that position. And they take that position because they figure if you ever take away that 50-50 almost rule. Now, if it's a gentle presumption, let me add this, if it's a gentle presumption where we walk into court and that's what we think we're going to do. But if you show us evidence either other way, we'll consider it. Okay, so let's say that would be the ideal from my perspective.
Mm-hmm.
But if there was a time when guys thought that it wasn't anything, that the best they could hope for would be 50-50. If it ever changed, it would always mean they lose. But now we're coming into a world where that may not be true. It may be that if you walked into the court with the rule that I just described, that gentle presumption, where the scales can be tipped without having a smoking gun, then and guys are truly on a level playing field in terms of candidates for that primary parenting role in such a scenario. I would like to think that most of those guys, men's rights advocates, would agree that, okay, that's probably the right thing from the children's perspective and the parents' perspectives. What are your thoughts, Kendra? What are you hearing as a legislator?
We're actually hearing that, Kentucky has moved to that. I think it's been about 2 years now, and they're actually showing that there's less people coming to court, which means less money for attorneys, but less people arguing, less false allegations of abuse, So they're staying out of some criminal courts. That is a civil matter. So they're actually proving that it seems to be helping, and it seems to be helping the children that they can negotiate on their own. And I know this is also something big in Sweden. Sweden does this. As soon as they separate, they are 50-50, and they hardly have any court cases that come in because it's forcing the parents, even though they might have their own personal vendettas against each other, that's forcing the parents to actually be parents for the children.
And here's another perspective too that I'm good at playing devil's advocate.
Sure.
One thing about being a lawyer is you're used to sitting on different sides of the table, and even though I've sat on one side most of my career, I still have a good perspective. And I can see the argument though in this case that could be made that in favor of the 50-50, even almost irrebuttable presumption, and that would be that the parties found each other. They chose to parent with each other. The children are kind of swept into this, but let's talk about it from the parents' perspective for a minute. And so they meet each other, and they each make the decision that the other is going to be their co-parent, their partner for life. But it's one thing to be a partner for life in marriage, but they're co-parent for parenting the kids for life, in a sense of the word. So when one of the parents comes to the court, and I've been sitting in judges' chambers when this has happened innumerable times, and one of the parents, hopefully not one of the attorneys, hopefully not me, is saying, "Judge, this other person is crazy." Okay, it has been me a few times. This other person, this other parent is insane, Judge. My client is trying to get away from this crazy person and protect the children in the process. Judges have this spoken or unspoken position, often spoken, in which they say, "Look, I didn't choose this person to be their co-parent. They made this selection of a partner, so they're the ones who made this decision, not me. What they have now is a child that they both contributed to with the consent and encouragement of your client, Mr. Cordell." So judges tend to think that, look, they started out with this decision to co-parent, and by golly, they're going to live with it. Now, that's not a best interest of the children's argument, but it does have a certain equity to it. What do you, Mick? You look like you're about to say something.
Well, just I was thinking of, because these are really good questions, really good areas. I'm looking at in my particular case. I was think I'm the Murphy's Law of custody and parental alienation. Whatever could have gone wrong went wrong. And here are some things that came up, and I think only from an attorney can you get a solid answer on these kinds of things. What do you do when that other person that I would consider crazy takes your child and they end up 3,000 miles away? How do you get that child back? Because that happens, and other people say, well, that never happens. Are you kidding me? I know people that's happened to me. So what can you do about those types of things? And a secondary question related to that is, I've got the so-called court order. I think, because I love my country and I believe in the rule of law, if it says it's a court order, it's a court order, and I'm going to do everything I can to live up to it. On the other hand, the crazy person won't, and they ignore the court order. So what do we do in those kind of situations where you have to try to get a child back from a very distant place? And what happens when the other person is not listening to court order? I know the answer. You go back to court, you spend a lot of money, and you get a little bit better situation. So I'm wondering how you would handle those kinds of situations.
Well, a little bit of context here would be helpful for people to realize how far we've come. Before these Uniform Child Custody Jurisdiction Acts, which in various forms started in the 80s, I guess, it was common practice for people to go to another state. And remember, this was at a time when states were, legit quasi-independent entities. And it was very difficult for you to get anything done in a neighboring state if a mother took a child there or father. And so in order to get rid of that, states adopted this uniform statute in which they agree to cooperate in enforcing these. So I'm just saying to set the stage, Mick, it is bad in many ways, as you described, but I want people to know how crazy it was. If you remember, there were documentaries on TV in the 70s where people one parent be waiting for the child to walk out of school and would have hired people whose job it was to grab the child, throw the child in the car, off they go. They're on an airplane or whatever means it may be, and they're in another state, and that parent is powerless because you couldn't prosecute for kidnapping at that time. There was no such thing as parental kidnapping. So, I mean, you almost had to go to the new state, start new litigation in a forum that's probably not going to be very friendly to you. You may not even agree with the judge's decision. So now we have this situation where we do have on the books laws, and we have this uniform statute. We do have criminal statutes under parental kidnapping, et cetera. So I think there are a couple things going on when this happens. It happens, by the way, much less commonly than it used to. I mean, you saw it, Mick, but it's much less common. I think that part of the problem right now is that we have laws on the books, but I didn't realize until the last year and a half, because I'm not a criminal lawyer, I didn't realize until the last year and a half how important it is to have a good prosecutor and people who, and judges too, but people who will act, because if a prosecutor doesn't act for a set of criminal statutes, then it's irrelevant. So right now we have going across this particular complaint you have, to the extent it's happening now, and of course it is, along with many other types of crimes and unlawful behavior. The reason it appears so epidemic is in part not so much that the incidence of occurrence has increased, although it has, but even more so because it's no longer being prosecuted. It's no longer, there aren't people available in part who will run it down and do the things they do. And so some categories of offenses, they've made a policy decision where they're rationing resources, and local social services offices as well as prosecutors' offices. They're making decisions to wall off certain types of issues or offenses that they just feel that in the effort to ration scarce resources, not so much money, but human resources, that they are not going to pursue these things. And I know that in that bucket of stuff are things relating to child custody, I'm afraid, in many jurisdictions.
Yeah, can you speak to that a little bit more, maybe? What are you seeing from your clients as far as false allegations of abuse?
Now, again, I will. I won't speak for every state, of course, and I would encourage that, to the extent that we do something similar, it might be good to have 2 or 3 of our lawyers, like partners from different states, and see what their comments would be, because in each case they'd only be doing divorce litigation, period. That's all our attorneys do, and they would both be only doing it in those jurisdictions. So It would be interesting to hear. And sometimes we do in-house sorts of symposia and training where we'll have at the front of the room. I will say this. Now, I may be contradicted by one of my attorneys as to many other states, but that was the go-to strategy. So beginning, I would say in the 90s and in the early 2000s, the go-to strategy was an allegation of sexual abuse. That was the thing, right? And physical abuse too, but sexual abuse, they found, really was a powerful card to play.
Which is so sad. I mean, how can a father feel like he can't give his daughter a hug because he's going to be charged with sexual abuse or accused of it, right? That's just, it just breaks my heart.
And really, like physical abuse, it's like a battlefield nuclear weapon, though, that's only available to one side. Because as a practical matter, you may say, well, women could be accused of it. Well, they could, but when were they? They never are, because guys know that it won't be taken seriously. I can tell you this, just a tangent, just a second, is we had a guy, we went into court, he had a broken orbital, whatever this bone is around your eye. It was broken. The woman, his wife, struck him and broke this bone. So we had the evidence this happened. But my client was a bigger guy. Now, this wasn't one of my attorney's clients. So our client, the husband, was a bigger guy. So the judge we went in for an order of protection, which in any other case would automatically, I mean, no questions asked. That guy's out of there. As a matter of fact, he's in jail. He would be in jail. So in this case, the judge was a little dismissive, thought that maybe our client had provoked it, suspected that our client was being manipulative. And he says, okay, I realize I have to issue this order because there is physical abuse. So, but I'm going to let her stay in the house. So in other way, I have so little fear and so little trust in what you've told me. Tell you that judge would have been on the front page of the local newspaper if he had done that with a woman with a broken bone in her face.
Yes.
But that's how seriously it's taken. So it really is. When I say a battlefield nuclear weapon, I mean it in the sense that it will change the outcome of the case. So, and one party has it, the other doesn't. So sexual allegations, that was popular in the 90s. It's less popular now because it became, judges, to their credit, became very punitive when those were made, and you got a GAL who testified that there really was less credibility. And that often, thankfully, I'll say, it did happen that it was said. In the cases that I was involved in, we got an expert to say that it was not meritorious, that it was frivolous. So judges came down very hard because it was the most heinous example of alienation. If you think about, what is alienation in its worst form? It's those actions that are intended to legally deprive all access of another parent, all access of the other parent. And so judges became very punitive in most courts. I'm pretty confident to say that that's not thrown around freely now because judges, to their credit, became pretty harsh when they thought that it was entirely fabricated from whole cloth. But again, I know it happens. But what now is the go-to form of that weapon is the order of protection. The order of protection accomplishes largely the same things without having the gravity of the issues that you'd otherwise have. And that's where, a party goes in, the requirements are something to the effect that I have reasonable belief of some form of that harm might be imminent. Imminent is the word. So what does that mean? It means, well, maybe he's talking loud to me, it was in my face in the kitchen on a Saturday night. I've told all my clients, walk away from every confrontation, verbal confrontation, not to mention physical, but every verbal confrontation. Because I tell him, this will end up with the cops coming to your house, and guess who's going to be in the back seat of that car? It's not going to be her. And so in this case, the temptation is so great. It's a custody battle. And you have the ability by going to the courthouse and making this relatively mild statement, with some imagination that you can even persuade yourself there's truth to, and magical things happen. Suddenly this guy is thrown out of the house. He's gone for what is supposed to be 15 days. It probably ends up being closer to 30 in most jurisdictions with no hearing. And then when he shows up for his hearing, it's not a hearing. It's a cattle call where you have the judges devoted 10 minutes to the docket that morning. There's 33 guys in line. And are you going to be the one who's going to say, I want a trial, judge? You're going to keep me in here all afternoon doing a trial. You better have good evidence. Well, that's not exactly. Even apart from that, they're told by their lawyers, but before they even walk in that morning, say, look, we can fight this, but it's he said, she said, and you need to know what the consequences are. If the gavel goes down against you, you may lose your career. Say they're a school teacher, various careers. It could end your career. You can't own a firearm. Maybe the rest of your life, depending on where you're living. And you're going to be known as this batterer. It's going to be in your record if you ever go for public office, anything like that. It's just out there. So all these doors of opportunity in your life are suddenly closed because this woman, in this case, in 99% of the cases, it's a woman who does this, and goes into the courthouse and files this. And so what would a guy do? The guy, there is an opportunity that's extended him an olive branch, but it comes at a price. The deal that he's offered by opposing counsel is he can say, okay, I will agree to consent to a consent order. I'm not admitting I did anything wrong, but what the reason that for him that's tempting is that there's no gavel that goes down of a finding of guilt. So none of those bad things flow. But in order to do that, the other opposing counsel says to him, he has to agree to let the wife have exclusive possession of the marital home. He has to agree to maybe pay certain amounts, blah, blah, blah. And furthermore, it's going to come up in a custody battle later, and it won't be favorable. It's not as bad as if the gavel went down. I didn't throw that in. He loses the custody battle. End of the subject by law. So the moment that the gavel, if he tells that judge that morning, I want a hearing. And remember, judges are self-protective. They think about their own lives and careers, and they don't want to be on the front page of the newspaper having denied this order. So what's the safe thing for that human being sitting in that chair? Put aside biases. Just in fairness, he's a human being. He or she's a human being. So guys need to know, and they do know, the odds are stacked against them. Now, do we try those cases? Yeah, we do, but we pick our cases carefully, meaning that we don't try every case. We don't use our client to make a point. Our client doesn't want to be a point. I mean, they want to be a victory. So this is what I mean when I say domestic violence or sexual abuse as an allegation. Those things, are really game winners if used properly. And now it's largely, in my opinion, shifted to orders of protection.
Yep. I would 100% agree. I'm the 1%. I was accused of abusing our children, had to go through that, and led to the whole temporary custody. Then he got full custody, and now I'm not seeing the kids or talking to the kids. And it has turned into alienation. So I am that 1% where it is flipped. Yeah. And I'm experienced at this, and I get it. And I was the one that said, let's go to trial. Let's, I didn't do this. Let's prove it. And we got to domestic court trial, and he dropped it. He did file criminal charges, and we went all the way to 1 week before trial, heard the depositions, and the judge and the prosecutor threw it out because they said this absolutely did not happen. So I am that 1%, and I fought it for 4 years.
Now, let me say this too, Kendra. I winced a little bit a while ago when I said that these are 99% women doing it. Although I stand by that, but I want to make something clear. Any men or women would do this. This is not a criticism of the particular side of the table that has this wonderful weapon available to it. Anybody would use it. If it's a parent who loves their children more than life themselves, which most of these parents do, then if males had it, males would use it. Mm-hmm. But so my criticism is really against the legislatures and the courts. They're allowing this to be done in a game that's life or death, and everything is on the table. And divorce is closer to that than any other area of the law, including criminal law. And when you put so lifeline or a ready solution, it's too tempting. Weapons are out there because we know that if somebody's backed in a corner, God forbid Putin be an example of this, when you're backed in a corner and everything's at stake, you figure I'll do this. And I think domestic relations sometimes becomes that with orders of protection and allegations of abuse.
Yes. Yeah. No, I agree. And it can happen on both sides. It's like you said, it is a weapon, and courts need to be aware of it and how much damage it can cause the kids on the back end, because ultimately that's who suffers right through all of this.
Yeah, I agree. But here's what part of the problem is that there's no army of resources. There's no legion of organizations that are overflowing with funds and support that are determined to take on this civil rights issue. It is a civil rights issue, but it's funny. It's kind of the dark corner of the room where no resources are being sent there. No one really cares. We've made so much progress in civil rights in the last 50, 60 years, but not in this area, or at least if we have, it's been very, very incremental. Nothing like the progress we've seen in other areas. And in part because it's men. Men have not been the center of focus in this civil rights revolutions. For whatever reason, maybe it was thought that it was a matter of shifting the tables from men. I don't know, but anyway, so this is if we had half the government resources, if you think about the governmental entities, the billions of dollars that are made available for women's issues, many of which are legitimate women's issues, of course. This is not an argument against women's equality and all those wonderful things that have happened. It's an argument against concluding that men, it's okay for them to be treated in an unfair way, and that somehow that resembles justice.
Yeah.
So I'm not real optimistic because I don't see the resource. I don't see where those resources are going to come from.
Yeah. I tend to agree with you on that. And I know Mick's very passionate about this too, as he wrote a book, Burning America, because we are very passionate that the system is broke in general. And I think you agree with that, Joe. It sounds like. Can you talk about two different things? I know we're running out of time, but what is parental alienation? How is that viewed in the court? And then, what you're seeing with the guardian ad litems. Are they adding value? Are they not? I know when I first started, I did not realize the guardian ad litem, at least in Ohio, is assigned through the case till the kids are 18. I don't know if that's in every case. And, are they adding value, or is this something that maybe needs to be looked at?
Let me first speak with the Ohio statute. That's not typical. A guardian ad litem can be appointed for an interim period for the court to define. And excuse me, in most states, the guardian ad litem would be appointed throughout the litigation process up until the case is completed. Now, if you have a guardian ad litem appointed in juvenile court, that is typically somebody who would continue to be involved throughout the minority of the child until they're emancipated. Anyway, a guardian's ad litem, I can tell you, it's something that is a powerful force. It's what would be an analogy? It's like an 800-pound gorilla in the process that once you admit into the room, then you can't predict its behavior sometimes. And whatever its behavior, its influence is far disproportionate to what you would want. So it's dangerous to invite even a GAL into a case. And often now again, this will vary with states. Some states, there would be a presumption of an appointment by the judge if there's a custody battle. But in many states, it's entirely discretionary. The judge can do it on their own initiative, or more often, the judge will only do it when one of the attorneys make a motion requesting the appointment. And then, of course, they will appoint such as a GAL. But the GAL, you need to keep in mind, for those, you may know this, but many of the listeners may not. GAL often comes from a list that the judge has. Now, sometimes this is a list that the judge has created and prioritized according to his or her preference. Other times, it's required to be a list in which they rotate in some fashion. But I'll tell you that more often than not, in the substantial majority of cases, this person is going to have more credibility in the judge's mind than either of the parties, much less their attorneys, and even much less their witnesses. So I just think that it's a dangerous thing. And I've often told clients where I felt that we had an edge in a case, where I felt the evidence was on our side, I said, let's keep this between us and the opposing party. Let's not invite a party into this, a third party that's going to determine the outcome, because it's dangerous. We don't know for sure who that will be. Now, I've done the opposite. I've had a case where I felt that we had strong facts if somebody took the time and the effort to investigate them, but I didn't feel that at trial we would be able to communicate that, or maybe I just felt the facts were not real strong, and maybe even in that case too. But I wouldn't invite a GAL unless I felt that we were at a substantial disadvantage, and I thought I could predict who that might be. So if you throw in those two factors, I don't think I can do it on my own in court, because I don't see the evidence is there for my client. Then you want another metaphor to use would be a wild card. So when do you want a wild card? You want a wild card when you don't have a winning hand, not when you have a winning hand.
Yep.
You don't want the other side to have a wild card that gives them a shot they wouldn't otherwise have. So, but I've wanted that wild card in a case because before where I knew I didn't have any other shot, and I thought I knew that the person the judge is likely to select, and I felt that I could do business with them, so to speak, not in an unethical way, I mean, but that I could influence them, that I could talk to them, I could persuade them. The lawyers have got to be involved with these GALs. I mean, this idea that there's some sense of propriety where the lawyer is supposed to stay back and let them, be do their business. I don't trust them to do their business on their own, and maybe that's unfair, but I want to argue for my client. I want to advocate, and I want to coach my client on how to deal best with the GAL. Too many lawyers take this laissez-faire position regarding GALs and other experts. I don't, the only line on that is ethics. So, there are probably ethical rules that are crossed where you suggest a client say something that's not true. I would never do that. But it's not unethical for you to prepare your client for that meeting. And lawyers that don't do that are more concerned about propriety and niceties of protocol than they are about their client's victory. And so clients should be coached and in a proper way, and the lawyer should be engaged. But now, one other thing you asked, though, and I didn't get to it, was the definition. The working definition that the court has, I can tell you in their mind, alienation, and it works for me, is this effort on the effort of one parent to minimize the role or the influence of the other parent in the child's life. And that's really irrespective of motives, meaning their motives may be the best. They may think that without doubt believe that they're doing something that's important for their child. Those are the most dangerous parents, incidentally. Those that, and you've seen those cases where, I'm thinking of a mother actually that, she ended up in prison because she was convinced his dad had committed sexual misconduct with these children. And she took the kids and went off to another country, and they were gone for years. And this woman, nothing would stop her. I mean, there was nothing they could do but lock her up because she was going to run and grab those kids. I have no doubt in my mind she believed what she was saying, but she was delusional.
Yeah.
And she was very dangerous. Now that's alienation in its worst form, but alienation can also be far more subtle. And I would argue this is almost the more perhaps the more poignant in the minds of children, is when grandma and mom are in the kitchen. Let's assume it's dinner. They've just finished eating. Maybe mom and grandma are in the kitchen and talking, and grandma says to mom, well, is the parents, Bill will say, I guess Bill will probably not show up tonight, or is Bill supposed to be here on time this time, with a tone and maybe just raised eyebrows, nothing more. Let me tell you, and you all know this, I mean, a child that's 4 years old, maybe younger, is reading that, and that's a flashing neon sign. Dad's irresponsible. Dad's dishonest. And it's probably even more effective than they're saying it, because they think it's so true that their behavior and their words convey their belief, and yet they're not telling the child. So, I mean, it's the most pernicious form, and yet it's so hard to diagnose. It's difficult to uncover when a child has observed that and come to the conclusion that dad's a deadbeat and that cares more about his girlfriend than his child, and perhaps those words were never said per se.
And it's extremely hard to prove in court, and tell me if you disagree, Joe, but I think it's extremely hard to prove in court any emotional trauma the children's experienced related to that, whether it's mild or severe.
It is hard. And the comeback on the other side is, well, look, Judge, this child's 10 years old. Mom is trying to get him to go visit his dad. But what can we do? The dad has done all this stuff, and my client's done all she can to keep, patch this relationship together. But this guy's just impossible. And I'm saying that's the line. That's the line. And ultimately, you've got to have an expert that's going to uncover that. And the only experts I trust, to be honest with you, are my own. And I hate for matters of great consequence to be in the hands of people other than the judge. And the judge is bad enough, but then to throw in another element. But if you don't have experts, you're never going to diagnose that, I'm afraid.
Yes, that is very hard. Well, Joe, it has been wonderful speaking with you. I know we took some extra time, but the good thing for you is people are always going to keep getting married and keep getting divorced. So,
Well, I'm happy to
unfortunately,
go
we all
on.
got to work through this.
Well, I think you're right, but I'm happy to move on to a new practice area if this ever dries up. So I've kidded people that someday I'm going to give up this law and do something like estate planning, which is happy law. Where everybody walks away happy. You do a will or a trust, and So no, you're right. Domestic relations is not happy law usually. So occasionally it is.
Right.
All right. Thanks, Joe, for being our guest today. It was really awesome. That's it. We did go a little bit longer, but it was really valuable. So thanks for taking out some time from your busy schedule and chatting with us today. Much obliged.
Thank you. I enjoy it. I wish you all both the best.
Thank you so much. Well, hopefully, if you've enjoyed this more to come. So if you have not subscribed to the Aftermath, please do so. So like, subscribe, share, and also positively review on Apple Podcasts. That helps a lot. Until next time, more experts, because we are fighting the good fight. And absolutely, this is the civil rights issue of our time. And some of us write books called Burning America because this is an important issue. Until next time, this is the Aftermath signing off. Deus Volt.